I don't know, after hearing him calm and talking about the tether story, it's probable.
Go down to the county attorney's office. I think you'll find a lot of humans down there.
All right.
No disrespect.
Stop driving.
I'm flirting with the judge in front of my dad.
What's going on? This is Colin. How's everybody doing? Happy Friday night. It's Friday night. We made it to the end of the week. Congrats, everybody. It's the weekend. I got an important announcement, but I'm going to wait for a few other people to come in. So we're going to watch the first court clip. And after the first court clip, I will proceed with my announcement. So, without further ado, let's watch. Before I hit the play button, you already know what to do. Hit that like and subscribe button, do your drunk kick backflips, and if you'd like to donate, my link tree is in the description. Please and thank you. Let's go.
What is this? Thank you, so good. You took some out. Okay. Such an interesting out there.
All right, good morning. We are on the record in the 89th District Court for the County of Sheboygan. We're conducting the physical hearing upstairs in the circuit courtroom. It's being clerked by the 89th District Court staff down in that courtroom. And we're here in the case of In Re Beth Bridgman on a contempt matter. It was filed in an underlying criminal case 23-0868 SD. We are providing public.
All right, I jumped into this way too fast. We have SovCits and Idiots tonight. So this is a SovCit. The next clip is a SovCit. I have another SovCit after this. I think there's 5 or 6 clips in this video. It's about an hour and 15 minutes long. It's a longer video, but lots of SovCits. This one happened today. The one after this one happened today. The one that I have playing later happened 2 or 3 weeks ago. But 3 SovCits in one video. Can't go wrong, right? And then I got some idiots too. Well, kind of the same thing. All right, let's go.
Access both in the courtroom, in the circuit courtroom, and also online. Counsel, you want to state your appearances, please?
Good morning, Your Honor. Paige Miller on behalf of the people.
Attorney Eric Villanueva appearing as arraignment attorney on behalf of Beth Bridgman.
Right, good morning, Ms.
Although I will represent myself.
Yes,
Okay.
we'll get to that.
I would like to say I'm here on special appearance. No, I think I have some rights here. I don't know.
What does special appearance mean to you?
It means in a common law that I'm a living soul. I am not the straw man of the all caps.
And you'll have an opportunity at a later time. Please just take a seat.
I've never seen those opportunities come back around. Thank you.
We'll
Okay.
get to that in a moment.
So
but
I am
now's
waiving,
not the time.
I am not waiving any of my
Ma'am,
rights.
Ma'am, okay, thank
And
you.
Ms. Bridgman, you're free to stand or sit, whichever you're more comfortable with.
I don't know how I'd pull a chair up, so thank you.
Well, then, if you want, if you want to sit there, I have no problem. All right.
Thank you.
All right, well, Ms. Bridgman, you're here for an arraignment on 2 allegations of contempt. So I have to advise you of what those are. The first was an order to show cause that I signed on December 13th, 2023, which alleges that you are in criminal contempt of court for the unauthorized practice of law and for preventing the defendant, Seth Flores, from meeting with the Michigan Indigent Defense Commission attorney prior to his arraignment. We scheduled that for a show cause hearing on December 20th. You did apparently appear in the courthouse that day and turned in a copy of the show cause cut into strips with the red lettering on it says your offer to contract is not accepted. And then you did not appear at that show cause hearing. So therefore I signed a warrant for your arrest for that non-appearance. So that warrant alleges that you are in criminal contempt for failing to appear at that show cause.
So,
Failing to appear for order to show cause on Wednesday, December 20th, 2023 at 11 a.m. for preventing defendant Seth Miguel Thomas Flores from meeting with MIDC attorney prior to his arraignment. So those are the two contempt citations pending against you. You have the right to have a hearing on both of those allegations, where your contempt would need to be proven beyond a reasonable doubt. You have the right to present evidence in your own defense and cross-examine and challenge any of the evidence presented against you. You have the right to an attorney. If you qualified and requested, you have the right to an attorney appointed at public expense. The MIDC provides an attorney for your arraignment today, just as a courtesy and as required by a
what is
statute.
MIDC?
Michigan Indigent Defense Commission.
You also, of course, have the right to represent yourself. Do you know, well, first, do you comprehend the penalties? Oh, I'm sorry, I didn't tell you. So both those contempt citations, if you are found to be in contempt or you admit to being in contempt, you could be punished by up to 93 days in the county jail and or a fine of $7,500 or both. That's the fine, that's the maximum penalty for both of the contempt citations. Ms. Bridgman, do you comprehend the rights that you have that I outlined for you and the maximum penalties I outlined for you?
I think that I would like to wait. I have a call into the state trooper that your office or the prosecutor's office called to investigate something with me. And I was on the phone with her and told her I had received the show cause, and she said, he can't serve a show cause. I shot over a copy of it. He can't serve a show cause because you're not under bond. This is from the state attorney general's office. I was still on the phone with her. I had filed the paperwork at 9 o'clock. She called me at approximately 10 o'clock. I was still on the phone with her till after 11 o'clock. And she told me that you could not issue a show cause because I was not under bond. Now I understand you have just precluded all of my common law rights by forcing me in the back door into your jurisdiction on this side of the court. And I know that this is not what was on the original document in its entirety. So you have amped up the charges based on the fact that I failed to appear, but I believed she was going to let you know. She was collecting information from me for you.
Ma'am,
Okay, now,
did you just understand what the judge asked you regarding those two charges?
Did you just understand that I think there's a bigger overriding issue? Thank you.
All right, fighting with the attorney right out the bat. This woman she's just amazing. She knows more than the attorney and more than the judge does. I mean, I think we're about to learn a lot from her. Let's keep going.
Wait, hang on.
Thank
I'm
you.
not going to have this.
I'm going to fire him, actually, so thank you very much, because I will represent myself.
Okay. So you're telling me things in defense of the contempt citations, and you'll definitely have an opportunity to present. any of
No,
that.
because you already,
Hang on, Mr. Villanueva, please stop. I don't want to have this be an argument between
Thank you.
and Ms. Bridges.
I guess I just like to, state that
well, I think we need to
she's
back it up.
pleading not guilty to both of those, and that she would like to request a hearing, that she would like to represent herself at that future
Okay.
hearing.
No,
Your
but
Honor, I
all
just
of my
want to-
rights were strongly impinged upon for, even when I never failed to appear.
Okay. We're going to have a hearing where you.
She
can
was
present that.
working, okay,
Okay, you're gonna get your
Mr.
hearing.
Villanueva,
No,
I'm
this
directing you to
is-
stop
thank you.
arguing with Ms. Bridges.
All right, just wait till you find out what she did. She's retired now, but wait till you find out what her job was. And she's still a sovereign citizen. Kind of blows your mind. I will come back to this point, but that was the biggest surprise to me during this entire clip is what she's retired from.
Okay,
No spoilers.
I mean, it's a pretty serious thing to have to spend the night in jail, to be brought in handcuffs and everything else. When I was not being belligerent in that regard, she told me that it was not an authorized show cause.
All right, if she told you that, she didn't have the authority to do so. But anyway, that's for the later hearing.
He was
purpose is
investigating,
to-
okay.
Today's purpose is to advise you of the 2 contempt citations. So do you comprehend the maximum penalty that those could carry and the rights that you have that I outlined for you?
Now, can I ask, what statutes or what law or what are you saying he charges? Because this does not match, sorry, I have cotton mouth so bad. This does not match what the previous document was that you sent to me, and I have a picture of it on my phone, but my phone's not with me. Okay,
I've
it
told
does
you
not
the-
say,
I've told you the charges. I don't have to answer further questions about that from you. Do you understand the rights that I listed for you and the penalties?
why have they changed,
I'm
Judge
not
Guthrie?
answering that question.
Can the prosecutor?
No,
What?
I need an answer to my question. Do you understand that? So you said you want to represent yourself, right? You wish to represent yourself and not have an attorney represent you?
Yes, I
Okay.
do.
If you want to do that, I must establish that you know what the penalties are and what your rights are. And I have to establish that you're not going to be disruptive to the court. If you refuse,
So are those,
then I'm going to appoint
not
an attorney for
refusing.
you. Okay, then I would appoint an attorney for you and you'd not be able to represent yourself.
I know, I listened to that with Trevor's case.
All right, so
Okay.
I'm asking you, and you saw what.
How
happened,
can I
Ms. Bridgman? So I first have to make sure you know what the maximum penalties are and what your rights are. Do you not?
Those maximal penalties, charges, and I'm wondering how you arrived at a change in the charges.
I'm not answering that question. You know that you could face up to 93 days in jail and over $7,500 fine. You understand it.
Up to that, okay, but I don't even understand what the charges are.
And do you have any questions for me about any of the rights that I listed, that you have to have an attorney and have a hearing and present evidence? Do you have any question about any of those rights?
I have a whole question about the whole,
Do you have any questions about your rights? I've got a whole question. Wait, what? I have a whole question. Not a half question, not a quarter question, not even a 1/3 question. She's got a whole question about her rights. This woman is awesome. She's going places. Follow her for more tips.
context of everything today, Judge Gothier.
It's really quite simple. When you have an order to show up for court and you turn in a cut up piece of paper of it to say you're refusing to attend, that this is what happens next. That's pretty simple.
Oh, did that offend you?
No, it did not offend me. It was a contempt of court.
It's a
It's
common law
not about
thing.
anybody's personal feelings. It's about the authority of the court to compel appearances. You did not appear. So I do believe, based upon your answers, that you do understand the maximum penalties that you face and the rights that you have. So, Ms. Bridgman, Mr. Villanueva indicated that you wish to plead not guilty to those charges of contempt. I gather from your comments that you would agree that you're not pleading guilty.
Correct.
That's correct. Okay. All right, so we'll enter a not guilty plea on your behalf to both contempt citations. We'll schedule this for a hearing where the prosecutor will present evidence, and you can present evidence in your defense. If you want to have an officer come testify on your behalf, you can certainly do so.
I would like to request a trial by jury.
There is no right to trial by jury in a contempt matter. So
Oh.
that request would be denied.
Okay, so then there's no chance to understand what you're charging me with prior to this hearing.
I've told you what you charged. I can read it again if you want.
I don't see where there's a code or a statute or any law that I have actually violated here.
Well, that's
All right, Judge. She doesn't believe that she violated any law. Get her. Get her. You got this, Judge.
not required to be on a contempt citation. I've told you what the allegations are. If you want me to read them to you again, I will. I'm not
Okay,
gonna argue
and
with you about what they
And
are.
the contempt charges that you're saying have changed from the first time.
No, there are two. One is the contempt for unauthorized practice of law and preventing Mr. Flores from meeting with his MIDC attorney prior to his arraignment. The second one is for failing to appear for the show cause hearing on that contempt.
So I only show one now,
What
Okay.
one do you have?
and this is preventing. And how did you arrive at this at a later date than to issue a bench warrant?
Mr. Villanueva?
There's two items check marked here.
This is after the fact, so then you added a different charge than the previous one about the same date.
Ma'am, he read two charges. There's two charges marked here.
Excuse me. I probably have more degrees than you do,
All right,
okay?
all right.
Now,
I'm gonna find that,
what I'm,
I have more degrees than you do. She's got about 104 degrees, and her attorney only has the typical 98 degrees. You know, we're going to call up Nick Lachey because he has the right amount of degrees. This woman's running hot. I know that was bad. That was bad. I tried to run with it. After I started saying it, I realized how lame it was, but you know what? I just let it go. All right. Don't blame me. I'm a dad.
please, Judge Gothier.
sure, go ahead.
Thank you. Okay. So the first one was that I was practicing law. That was the first one. That's the show cause that you say I failed to appear for.
No, it was contempt for unauthorized practice of law and preventing defendant Flores from meeting with MIDC attorney prior to his arraignment. That was on the original.
No, I have a picture of the original one. This is why I'm not sure.
Do you have a copy of that show cause in front of you right now or no?
This one,
Would you like to see what she has
But-
here?
I just, Susan,
okay,
you don't.
so how do I defend?
Hang on. If you do not have in front of you right now a copy of the first show cause, I'm happy to provide a copy to you.
So how did you arrive at a second show cause?
Because you didn't show up. The second show cause is for failing to show.
But I wasn't on bond. So both show causes are not in effect because I'm not on bond.
Your Honor, what is the date of the first show cause?
December 20th.
No, the December.
Sorry, that was before the December 20th.
All right. You may view this document. This is out of the court file. You may view it and then.
So-
send it back.
Judge Gothier, do I have any other recourse to clarify where I was on that day and the information that I was going off of by your own investigator?
You do. You do. And
Okay,
that is a hearing date. Today, we're going to schedule a hearing date and you can present that evidence at that time.
and how will the hearing affect a trial by jury
As I told you, there is no right to trial by jury.
for
in
a contempt charge?
So I
Oh,
can
so
schedule
this is a perfect, nice little tidy package for everything. I see. Okay,
So I can schedule this for a contempt hearing on Thursday, January 11th at 2 p.m.
I think that would be way too soon for me. Thank you.
Why is that?
I need to get to some of the documentation and follow up with that state trooper, as well as perhaps a few other people, because I'm guessing, am I supposed to just talk to the prosecutor without the other witnesses that I had in my presence at the same time?
I could schedule this for the afternoon of Thursday, January 25th, then that gives you 3 weeks.
Thank you.
So we'll schedule this for a contempt hearing on both allegations of contempt on Thursday, January 25th at 2 p.m. And do I understand correctly, you do not wish me to appoint an attorney that you want to represent yourself?
And then who makes the decision? You make the total decision then?
Well, no, first you make the decision whether you want to represent yourself. As long
No.
as I'm convinced that you're doing so of your own free
Okay.
choice, that you understand what's going on and that you're not going to be unduly disruptive, then you'll represent yourself.
So what am I allowed to do at the hearing to defend myself appropriately?
You're allowed to present legal arguments. You're allowed to present witnesses to testify under oath,
Okay.
yourself or any other witnesses that you bring with you. If you want to subpoena a witness, if you're representing yourself, you can't issue a subpoena without the court's signature. An attorney can issue a subpoena on their own.
So
If
I
you want
can't
to
subpoena
subpoena
them.
somebody, what you would do is you'd go to the court clerk, they give you the paperwork, you'd fill out the subpoena. They would give it to me to review. And if it looks like it's reasonably, connected or relevant to the case, I would sign the subpoena and it would be given back to you for you to serve upon the person to compel their appearance.
I did not even get to watch the video that day because I was still on the phone with the trooper. And then people told me after I went up for Christmas that there was maybe a bench warrant, that you had issued a bench warrant. But everybody looked for it online at VineLink and couldn't find any bench warrant. So I was not trying to. I thought that trooper had told you what she told me, that I wasn't on bond, so I couldn't have a show cause.
Okay, well, that's all gonna be sorted out at the hearing, okay? We don't have to sort all that out today.
Well, that's a
Okay?
lot of overnight in being arrested downtown and everything for a misunderstanding that I would like to,
Mr. Richmond, I mean,
okay,
you're
I
not-
get it,
You're not.
Judge
fooling-
Gothier, I know what happened,
You're
but
not fooling me. I've got the show cause that you apparently cut up into little strips and wrote.
yeah, but I brought it at 9 o'clock because do you know that that's actually a common law practice? And there are courts that recognize common law because sovereign people and people who take an oath of office can follow common law.
All right, so the
Not the
contempt hearing
codes
on
and
both
statutes.
matters is scheduled for Thursday, January 25th at 2 p.m. I find that Ms. Richmond is unequivocally exercising her right to represent herself, that she understands the nature of the charges against her, the maximum penalty, and the rights that she has. I find that although she certainly disagrees with court procedures and processes, which is her right, that she's not being unduly disruptive to the court's business. So the court's going to recognize Ms. Richmond's right to represent herself at that hearing.
Can I ask one question? What are the parameters that you're going to decide is practicing law versus helping somebody maintain their unalienable rights? How would I delineate that in defense of myself?
Well, that's a question of, excuse me, that's a question of law that you can research before that day. And I said, I'll entertain legal arguments. The prosecutor will have to prove beyond a reasonable doubt at that hearing that you did in fact practice law on that day. That's where then there's a risk to representing yourself because an attorney, has access to and better training in researching the case law, interpreting what that is. The Michigan Supreme Court has issued some opinions about what that is. If you're representing yourself, you're going to have to find those on your own and make the argument as you see fit. If you want to hire an attorney or if you want an appointed attorney, they would be able to fashion those arguments on your behalf. But I'm not going to.
No, I've been
Tell
down
me
that
what
path
those arguments
before and it never turns out the way they first present themselves to you, that they're going to fight the case. It never turns out that way. So I'm fully cognizant and aware of that, but I wanted to see what your standard was going to be.
It's going to be what the law requires.
But I'm not sure which law you're referring to. So I have to research all the laws to determine what this says that is different than the first show cause.
She has to research. Oh, wow. She has to research all the laws. Not just a couple of them, all of the laws. Which means she has to research all of the objections. I feel like we're going to get a good trial. Hopefully we get to see it in person. Or on Zoom. On YouTube. Whatever. Hopefully we get to see it.
Yet, Ms. Richmond, if you want to represent yourself, it's a little bit more work. You're going to have to
I'm not
do
saying it's not more work. It's also not presented in a way that tells me what I'm really being charged with. Or that anybody has any proof of what they said here. So that's what okay.
All right, well, that's what we'll.
All right,
sort out those
thank
legal
you.
Arguments and the prosecutor will present witnesses at that hearing and you can present witnesses. As I said, if you desire the court's help in compelling the appearance of any witness on your behalf,
Okay.
submit a subpoena to the clerk's office that I would
Right.
review. It'd be the district court office
Okay.
that I would review and I would issue the subpoena. if it's-
So one of the key laws would be that in the state of Michigan, anybody practicing law should have, be a member of the Bar Association. Am I correct?
That is correct.
Now,
Ma'am, you have to figure that out at another time, okay? Now's not time to litigate this case.
Yeah, so I have arranged.
I
on the
get it,
charges
but
to set the
I
hearing.
appreciate,
I'm sorry, Mr. Attorney, sir. I fired you. Why do you keep giving me advice? Stop it. I know better than you because I have so many more degrees than you. Stop talking to me. I don't even know why you're sitting next to me. can you please take these handcuffs off? Why do I have these handcuffs on? Why don't you have handcuffs on? So many questions, all of the questions.
Appreciate that this is very big in scope, and Michigan statutes and codes, as he says, he's compelled to follow or must obey the dictates. Okay, I'm very well versed in enough constitutional things, so I have to know what the perception is there. So, thank you, I appreciate
And Ms.
any
Bridgman,
clarification.
I do have to follow what the, any decisions of the Michigan Supreme Court are binding law on the lower courts. There are constitutional system, Michigan. Also, any state governor are laws that this court and all citizens of the state of Michigan have to follow.
So the procedure that was followed here, I could still take up in another manner, correct?
I'm not sure what you mean by another manner. At the hearing, you can challenge the procedure of it.
I was talking to your investigator. She knew what time I had a court date.
Yes, absolutely. If you want to present that person to come testify about that.
She's not gonna come testify, I'm sure. She's downstate. She might write something.
Well, that's up
But-
to you, what you want to present. If you're going to
Okay.
represent yourself, you have to decide how you want to present your case. But I'm giving you the extra time you've asked for.
So this is a major judicial review. Okay, to decide if anything in our Bill of Rights actually applies to the Michigan code and statutes.
You have all the rights in the Bill of Rights.
Wait for this line from the judge. It might be one of my. I keep leaning into the mic, and you guys can't see me when I do that. Just realized. Hi. This line's good. This line's good. If you guys remember elementary school, you'll remember this.
I recognize all those constitutional rights. of course.
And most of what I talk about actually falls under common law because it's common that anyone could understand it.
All right.
That's
Ms.
why it's
Bridgman,
called common.
you set the hearing date.
Okay.
We'll arraign you on the charges. I'm going to recognize that you are exercising your right to represent yourself and discharge Mr. Villanueva from any further responsibility in the matter. The only other question I have to decide is whether you should be released on your own recognizance, or whether you should be required to post a bond before the next hearing. So I'm going to hear first
I
from
was
the
too early.
prosecutor and then from you on that question. Ms. Miller?
Your Honor, I would object to a PR bond in this case first because of the her failure to appear on December 20th. She had notice of that hearing date as she dropped off the show cause to the court that had the date on it. Further, an underlying case that this was initially filed, she encouraged someone to not appear for their court date or to leave the court before they were arraigned. So I do have a concern about her appearance at the next trial, the next date.
All right, Ms. Bridgman, anything you want to tell me with regard to whether I should allow you to be released on your own recognizance before that hearing, or whether
I showed up at 9 a.m., Your Honor, and anybody could call me if they didn't understand that. I filed a similar document in Mackinac County and they accepted it. Common law is a very acceptable kind of a standard if you know it and you know what you're doing. So maybe there'll be a chance that I can present some of these other avenues, because how does my country tell me to take an oath of office to defend the Constitution, but then I'm held to only codes and statutes of the Michigan legislative body, governor, and perhaps Supreme Court?
That's not how that works. That's not how any of
That's
this
the
works.
overarching question here, I think. And I think a lot of people,
well, I can
struggle with
recommend the
that.
Schoolhouse Rock video to you about how a bill becomes law and the laws.
oh, I
There we
know.
go.
Your Honor.
I also know we don't have a
Schoolhouse
lot
Rock,
of
let's
judicial
go.
review.
So
Your Honor,
as to
part
the
of
bond
the-
question, any input, Mr. Villanueva?
Yes, I guess I know you just released me as the attorney of record, but I guess in support of the bond on her behalf.
Yes, go ahead.
Yeah, so I like to advise the court that Ms. Bridgman is a resident of the city of Sheboygan. She advised that she's a former social studies teacher. She's presently collecting disability social
And I'm muted. Oh man. Yep, that's what happens. That's what happens. That's what happens when you have something really good to say. Yep. All I was saying was a social studies teacher I was aiming it towards Heather because I don't know if in Canada they have a class called social studies. Social studies is a class taught in elementary and middle school that's about government. That's what social studies is. So this woman is teaching kids about government, and she's a SovCit. That was what I was saying. But now that I've had to say it twice, it didn't come off the same. Didn't have the same ring to it. All right, let's finish this clip. I've actually got another SovCit right after this from Judge Perkins. Judge Perkins had a man of the land today. So let's finish this. Then we'll get into Judge Perkins' SovCit from today.
Informs me, I'm unaware of the status of if she has an automobile or anything. I'm not aware of any known criminal history for Ms. Bridgman, and she reports that she has no drug or alcohol issues. Granted, there's this allegation of not appearing at a previous hearing, and she was picked up, I believe, within the Sheboygan County for that. And so I advise that Your Honor. Oh, and one last thing, she's a politically active member in the community. She has audited an election previously, so I believe she's more or less, I guess, committed to this area, this local municipality. It seems unlikely that she would go anywhere, and how she would do that. And so, Your Honor, I would ask that you set reasonable bond for her release.
Thank you.
All right, thank you. Well, I don't believe that Ms. Bridgman poses any danger to public safety. I don't think she's a flight risk per se of fleeing from the jurisdiction. However, I do believe that she's a heightened risk of just flat out refusing to appear, as evidenced by the fact that she cut up the previous show cause into little strips and wrote that she wasn't accepting an offer.
Well, they
It
didn't.
wasn't an offer, it was an order
Sorry,
to appear.
they
and
didn't
you can't
actually
have
hand it
people
to
just
me.
refuse to appear on orders to appear by saying, sorry, I don't want to. So I don't think that release on her own recognizance would be sufficient to secure her appearance. So I'm going to set bond in the contempt matter at $10,000 cash or surety to the full amount. There'll be no special conditions attached to it, however, just the standard conditions, Ms. Bridgman, that you have to make sure that we know if you change we have to know your address, contact information. You can't violate any laws in the state of Michigan or any political subdivision thereof, and you must appear for all court appearances.
So the whole bond thing keeps me under your jurisdiction, which I wouldn't have come into your court the same way today, except that you put me in jail, so I was forced to.
That's the bond that I've set. So
This is the struggle between keeping my oath to defend the Constitution and adhering.
I've taken a similar oath, and I believe I'm going to do today, Ms. Bridgman. So we'll see you on the 25th.
We will look at the case law.
That's what it is. All right, we'll adjourn.
All right, I remember to unmute that time. But
I know.
unmuted.
She's only up here from North Carolina.
Who is she talking about? She's only up here from North Carolina. Who is she talking about? She said that as if it meant something to the judge. Anyways, all right. Next clip, Judge Perkins, another SovCit today. That one, I feel like a lot of people saw today. I saw a lot of people say that it was on Law Talk with Mike. He generally has got the air on his channel. This next one, I didn't see on anyone else's channel. This guy just, if you had to picture a SovCit, this would look exactly like a SovCit. Anyways, before I get into it, I do have a message. First and foremost, Melissa, thank you so much for your super chat. Also, Fred, you're always amazing, Fred. Thank you so much for your support. I don't know the easy way to say this, but you know what? I need to format my words. And I'll come back. I've got a lot of clips tonight, so I'll nail it for the next one. But if anyone would like to donate, link trees in the description. mods are thrown in everywhere. Let's go watch another SovCit, and then I'll format my words, and yeah, let's go.
Versus Bernard Brandon Little, case number SP 1513015, counts 1, 2, and 3. SP 1513029-1. Appearance for the record, please.
Yes,
Erica
Bernard Little.
Harris, Sherika Harris on behalf of Mr. Little. For purposes of arraignment, my client stands mute.
No, I don't.
You don't?
No, sir.
That is always a great start. I'm here on behalf of the defendant. He stands mute. No, I don't. I will not stand mute. The second you hear that as a content creator, you're like, okay, stop what I'm doing. This is a clip that's going on my video. Like,
I've got a payment plan devised from your department.
Turn your camera on, please, sir, first of all.
Okay. I just hit it.
Do you want representation by this very good lawyer, or you're not?
Well, she works for the state, doesn't she not?
All right, go ahead. What do you got going on, Mr. Little? What do you want to tell me?
What I'm saying is I got on a payment plan to pay these tickets. I got the payment thing right here in my hand.
Okay, you can pay him. You still got to do this no ops.
What's the no ops?
Without a valid license.
Say that again.
Operating a motor vehicle without a valid license.
Do I not have the right to travel? I have dominion over this land, right?
I knew
From my
that
father.
Judge Perkins, I knew that was coming. We all knew that was coming. My defendant stands mute. No, I do not. I guarantee he has the right to travel. That's the first thing that went through Judge Perkins' head, right there. Even the attorney right here is like, oh, come on, man. You gave me the guy yesterday that called you a dick. Now we have this. He's like, I just want a day. I just want one day where everyone just accepts plea deals or gets their cases dismissed. Just give me one day. That's what he's thinking right now. Just look at his eyes. That is what he's thinking.
I could anticipate that argument. All right. So that's not gonna. How do you want to proceed? Because I'm not buying that.
I would like to honor this contract.
I'm not buying that. I'm not buying that.
What you mean you're not buying it? It's your contract. It's your contract.
It's not my contract. You want a trial date? You want to work the deal out? Take failure to display, $240. Plead guilty.
They got me paying $400. They got me paying $445. That's what they got me paying.
Well, you don't want any help on that, so you want to come with the I have the contract argument, and
no, what I'm saying is this, Your Honor, not to disrupt you. I got on a payment plan because of the tickets. Y'all sent me tickets to my house, right? Okay. They put me on a payment plan to pay the tickets off right here. This is what I have in my hand. It's stating to pay the tickets off. That's why we're here today, for the tickets, right?
yes.
Or is it something else? Are y'all trying to get my bonds? Is my bonds here?
So here's the deal, sir. You have 3 civil infractions of improper plate, expired plate, and no insurance, and you have 1 misdemeanor, and that's a no ops. So the misdemeanor is punishable by 93 days in jail, and that's the maximum possible penalty is 93 days in jail and or $500 in fines. This is for purposes of arraignment for Mr. Little. And
Is that
let me finish. I'll let you finish. Let me finish.
Yes, sir. Yes, sir.
All right. And you have, you can pay a civil infraction anytime you want to. That is admitting responsibility by making that payment.
I've already made a payment.
There, you're not letting me finish.
Yes, sir.
The misdemeanors are not something that you can pay. Those need to be adjudicated first. So that's why you had to come to court on those tickets. I see that you entered into a payment plan with those civil infractions. So we're going to strike SP 1513015 counts 1, 2, and 3 from the record, and we'll just proceed with SP 1513029-1. How do you want to proceed? How do you want to proceed on the operating without a license, a vehicle without a license?
I don't believe I have the authority to travel as I need to travel.
All right, I'm denying that. I'm gonna consider that as a motion, and I'm denying that, okay?
It's no motion, it's a fact. It's a fact, Your Honor.
Well, that's what you argue that. You appeal my decision then, and you go to a further court and argue that. You take all that to the Supreme Court and see what they say. I don't care.
Why would I have to do that, Your Honor? If you honor your
I'm denying that motion. That's why. All right, so how do you want to proceed? Do you want to plead guilty today, or do you want me to set a trial date?
I'm not an animal, man.
You're breaking up, sir.
I say animals plead by high like that. I don't plead.
All right, so I'm going to set a trial date. You want a jury trial, or do you want to judge by a trial by a jury, or you want me to hear the case?
If I could not get a fair case regardless, Your Honor, because you're an agent of the state, and as if I get a jury, that the jury will be an agent of the state, because once they register to vote, they become an agent of the state. So how can I get a fair trial in that, Your Honor?
I don't know, but we got to move this case along. Let's get a jury trial date.
Yeah,
I'm not going to spend any more time. There's a lot of people here that want to get their case heard.
Yes, sir. Can I ask you what jurisdiction do you have over me, Your Honor?
Can I?
Go ahead, Ms. Harris. He doesn't want your representation. You're an agent of the state too.
I'll accept that. I was just going to ask the court if the court would consider dismissal based on the fact that he did pay other civil infractions and admit.
He hasn't paid anything yet. He only
yes,
paid.
I have. Yes, I have. I have paid.
He paid $20. He paid $20. He paid $20.
That's a part of my agreement. That was a part of my agreement, Your Honor. Not $40, not $60. It was $20. $20 each payment. That's what I did. I didn't give him more than what I agreed to. I gave him what I verbalized and I agreed to, sir.
Very good. Very good. Ms. Snyder, what do you want to do? Do you want to set a trial date on this, or do you want to dismiss the case and let him pay the other stuff?
Alex Schneider for the people, P80322. I missed what the actual charges he has left are, Your Honor.
He has a no.
We all missed a lot in everything that just happened. You're not alone, Miss Prosecutor. We idea what's going on, except for I think he has a popsicle stick in his hair. That's pretty much all I got from this entire hearing.
No ops. He has no insurance, and the others are civil infractions. No insurance proof, expired plates, and improper display of plates. He did enter into a payment plan. I saw. For the 3 civil infractions.
I'd ask that we keep it on the jury trial schedule, Your Honor. That might be something we consider down the road, but I think we can set it for jury trial now.
Did you see that smile? She knew that was going to get a reaction out of this guy. She said that, leaned back. She might as well put her hands over her head, put her feet up on the desk, and just waited for a response. She said that on purpose, and I love every minute of it.
Jury trial date.
Okay, let me pull it up.
Did we ever get an offer for Gregory Hall? Gregory Hall?
I'm ready.
I know.
I haven't talked to nobody in the break room though.
I know. I'm trying to get you that offer.
Fucking double.
Say that again, Mr. Say that again, Mr. Little.
Say that again, what?
What comment did you make?
I'm not sure what you're speaking
Speak
about.
up now. Speak up now. Say it. Speak up.
I'm not sure which one you're talking
Instead
about.
of talking under your breath.
I'm talking to another person on the phone. Another phone.
May the 7th. May 7th, jury trial date, 2024 at, let's say,
Your Honor.
yeah,
Okay. Yes, Your Honor. Is my bonds there in court today?
I don't know.
What you mean you don't know? You should know.
I'm not giving this any more time, but what I'm giving you now. Final pretrial date. Final is going to be, so your next court date, your jury trial date is going to be May 7th. And then we'll set a final pretrial date for the week before that, March the 30th. All right.
So can you tell me the two dates again, please?
March the 30th at 8:30 is going to be your final pretrial date. And your trial date is going to be May the 7th at 10 a.m. And as for the bond question, I don't see any bond down here. All right.
Are you done with me?
I'm done. If it's nothing further, be happy New Year to you. Be safe. I'll see you back on March the 30th.
New Year start April 1st, sir.
All right. Bye, sir.
Thank you, Your Honor.
Can someone explain that to me? Why does New Year start April 1st? That's the first time someone has said something, a sovereign citizen has said something that I didn't understand. Generally, they all follow the same logic, so kind of, you watch long enough, you get it. But why April 1st? I don't get that. I know someone knows the answer to that. Let's see, we're about halfway through. I know I ended with a lot of Judge Simpson. I don't know if Judge Simpson's next. But yeah, if you haven't done it already, please like and subscribe to your Jump Kick Backflips. And if you would like to donate or super chat, link tree's in the description. Mods are dropping the link. I would very much appreciate it. Please and thank you. Let's go.
All right, we are back in the record on the
You
record.
got a Washington.
Monique Cook.
Oh,
The court has had an opportunity to review the
special.
pre-sentence investigation report as well as the report. And based on some statements that Ms. Cook made regarding her lack of wrongdoing in this particular matter, the court is very concerned about whether she understands the nature of why she's before this court. And in addition to that, it appears that she has made a determination that she is only going to do the minimum, which is pay fines and costs in this case. If that's the case, it is the court's position we may as well begin with the jail time already. Because the reality is that, first of all, I feel as though Ms. Cook misled the court with respect to what happened on that particular date.
Why do you say that, Your Honor?
I'm still talking, ma'am. Please don't interrupt me. Um, and that when I took this plea, she gave me the impression that what she did was one thing, and the police report indicates that it was something completely separate. She was driving through the neighborhood in a very erratic manner. She reported that someone had broken into her house when it was really her daughter that was going into her home. I feel as though she does not take this matter seriously, which is a very serious situation at this point. And I'm going to adjourn this case so that I can, one, get the video footage. And if I find that she has been dishonest with this court, there may be actual jail time involved in this particular case.
Your
Ms.
Honor,
I'm still talking. I already interrupt me.
I apologize for that.
I already indicated when I was speaking earlier that I don't think you're taking this seriously, because your view of what happened that day versus what happens that day is completely off base based on what I have before me at this time. I'm going to review this footage, and if I continue to find out that that's the case, then we're going to be going in a very different direction with this case. I don't know whether you've been conditioned to believe that this behavior is appropriate because you're the mom and that makes it okay, but the reality is that it doesn't. So, having said that, if you think it's in your best interest to still speak, you may do so.
I do feel like I was out of character for reacting the way I did, but she had been being so disrespectful to me. And it was a lot. I had asked her prior to her coming to the house to wait till I got off work. And she knew that. Yes, ma'am.
You talk to your attorney before you say anything further, okay? And what I'm going to do at this point in time is I'm going to adjourn today's sentencing. I'm going to have it in person, and we can have a conversation in person and see how that goes, okay?
Your Honor, can I say something else, Your Honor?
Ms. Cook, I would advise you not make any further statements at this time.
Do you think I need to get a lawyer?
You have a lawyer.
I think I need a lawyer. You not? Okay.
Poor Lebo. Lebo just got called out. No. You have a lawyer. Yeah, I need a lawyer because you're not. Poor Lebo. Lebo. That wasn't good. Judge Washington is not going to let that fly. She's not going to say anything right now, but you don't do that. I put this clip in here because the next one is the one right after this is it's a really heartfelt clip. And between SovCits and Idiots, SovTars, we need a feel good clip. And the one right after this will make you smile a little bit.
Sentencing in this matter is going to be adjourned to February 8th, 2024 at 11 a.m. in person. Ms. McDuffie, please provide me with a copy of the video in this case, okay?
Yes, Your Honor, I'm sorry I missed that date. What was that?
February 8th.
Thank you.
Bond is continued. I'll see you here, ma'am, on February 8th.
She's going to jail. It's my guess. She's going to jail.
You're all set, Ms. Cook.
All right, here we go.
Calling
Feel
the
good
John
clip.
Fleming
Get ready.
matter, case number 23 FB 1311.
Rachel McDuffie for the people.
Mr. Fleming, you have to, there you go, sir.
There we go.
Please state your name for me.
John Fleming.
Thank you, Mr. Fleming. How are you today, sir?
I'm good. How are you?
I'm good. We're here for a review today. It looks like you are compliant at this time and doing exactly what you're supposed to be doing.
Yes, ma'am.
Looks like you just need to start working on your community service. And if you have proof of some you've already done, you need to submit that to the probation department.
I don't. I was just really busy with the holidays and work. I'm closing up a lot of jobs. I own a roofing company and I'm a single dad to 4 kids, so I got
Oh,
them full time. And with the holidays and shopping and like it's been crazy. But yeah, I'll be able to pay the fines next week. I just been waiting on some jobs to pay me.
okay. So if you get your community service done and your payments done, you can be discharged early. So we'll do a review in 60 days and see if you can
Okay.
get things done, okay?
Yeah, I'll have everything done within a month.
All right. Your review will be on, all right, I was just counting up how long you actually have. It looks like you're not, like you won't be done until May. So I'm gonna put this over to March. If you don't finish early, you won't be done until May. I'll put this over to March you think you'll be done in 60 days or you need some more additional
No,
time?
I'll be done. I'll be done in a month.
Okay, March 7th, 2024 at 10 o'clock a.m.
I'll make the time to do the community. I can do that now, but I was behind on work and all that. But I'm caught up now, so.
I understand. All right, sir, take care of yourself, okay?
All right, thank you, Miss Washington.
You're welcome.
Hey,
Have
I
a
just
good-
wanted to tell you, I've been in front of a lot of judges in my day, and you're a breath of fresh air. Your compassion for people, I see it. It's like when people make you have to do your job, that's when you do it.
Yeah,
But you really try for people, and that matters because you deal with a lot of hopeless scenarios. There's people dealing with stuff, you know.
yeah, they are. They are. And I
You know?
try
I
to
mean, it's
take
hard. Life's hard in general, you know.
it is. It is. It is. And I thank you for seeing it. Thank you very much. I appreciate that a lot.
Well, I
Thank you.
appreciate you. You're doing a good job.
All right. Thank you. Take care of yourself. All right. Bye.
Bye.
Judges don't get that enough from people in court. They really don't. Attorneys will say, you know, thank you and good job, but from defendants, they don't get that a lot. So when I heard that, I was like, oh, Judge Washington. Yeah, I feel it. I feel it. And it was right after a couple tough cases, and he was there for all of them. Mind you, he was smoking in court, didn't get called out for it. We're going to pass that up because of how polite he was and how he complimented Judge Washington. And if you didn't realize it, McDuffie was holding back a smile too. She was holding back. We almost got the signature McDuffie smile out of that. All right. Like I said before those clips, I do have, I think, 3 Judge Simpson clips. That might be what finishes this off. There might be one other one in between here. I don't know, but there's a lot of Simpson at the end of this video.
Good morning or good afternoon, everyone. This is the time.
All right. I forgot I put this one in here. See, this is why I said I don't remember. I only got half of this. The reason I put this in here is because it's awesome. And I really wish I had the whole thing because it is gold from start to finish. I just didn't get it. This happened on my way back from the airport when I dropped Heather off. And I wanted to get this so bad. This guy with the hair, so confused. And after the clip cuts off, I'll tell you how it finishes, but you got to see how it starts. And then you'll understand why I had to even just play the first half of this.
I'm set for first appearances. There's one individual that is not in custody. His name is William Dye. And I'm going to make inquiry. There's Mr. Dye.
Yes, sir.
Good afternoon.
Good afternoon, sir.
Mr. Dye.
Apparently I didn't even edit it either.
Good afternoon.
Mr. Greenwell, you
There
were
we go.
charged
This
by
is the
way
guy.
of information on or about December 31, 2023 in Butler County, Kansas with possession of methamphetamine, a level 5 drug felony. You're charged in count 2, same date and location, possession of marijuana after a prior conviction, a class A non-person misdemeanor. Count 3, you're charged, same date and location, driving while license is suspended or canceled, a class.
Do we still have Regeer's sex slave in here? There we go. Love slave, not sex slave. There we go. The second Regeer came up, I thought of you. Jabber Gear is love slave, not sex slave. Sorry to say that. That was very inappropriate. Kind of the same thing, though.
A non-person misdemeanor. Count 4, same date and location. Possession of paraphernalia for use. Class B, non-person misdemeanor, which the paraphernalia was plastic baggie, and 3 plastic tubes. Count 5, same date and location, expired tag or registration, and that is an unclassified non-person misdemeanor. And Mr. Greenwell, do you understand the charges pending against you?
Yes, sir, I do.
Mr. Greenwell, you do have the right to counsel. If you could not afford an attorney, one would be appointed to represent you. Mr. Greenwell, are you currently employed?
No, but I have money. I mean, I work side jobs. I do drywall.
How much money do you have set aside?
Thousands of dollars. I can't remember.
You have thousands of dollars set aside?
Yeah.
And so are you able to hire an attorney to represent you?
No, not at this time. I'm not.
Why, if you have thousands of dollars set aside, why could you not hire an attorney?
Because I don't have a way of getting to it.
What is this, cash money?
I don't know.
You don't know?
I
But
don't
you
know
have-
until I get out. I don't know.
Until you get out of where?
Of jail.
Okay, you said that you had thousands of dollars set aside.
I have some money. I have some money set aside. Is what I mean. I'm not broke. Is what I'm saying.
Well, when you say you're not broke, how much money do you have set aside?
I
that
don't
you
know
save?
until I get out. I don't have the money. My relatives have the money.
Okay, and the money is with your relatives, and to the best of your knowledge, it's in the thousands of dollars. Is that correct? To the
Yes,
best of
sir.
your knowledge. Okay.
Yes.
Well, based on that information, the court finds that you do have financial wherewithal to hire an attorney. So the court does not appoint counsel to represent you at this time.
Can you
Subsequently, you
Can
may
you appoint
retain
me
who-
an attorney? I don't have money to pay for an attorney right now.
Well, that you have money set aside to your relatives, and that's what the court understands is your situation.
Well, I don't have no way of getting to the money. I'm not going to be able to get to that money. My relatives might have money, but I don't have no money.
Okay, you're not, I need for you to not be contradictory in regards to whether you have money set aside or not. Do you have money set aside that could be used to retain an attorney?
No, I don't.
Okay, what's this money, and approximately how much is it that you have with your family, your relatives?
I don't know.
Yeah, that's what I was saying. I only got half of it before they cut it off. That they go back and forth for about 10 minutes about I have money, I don't have money, I have money, but I don't have money, so give me an attorney. It goes back and forth for a while, but that was pretty much the gist of it. You saw it. It's the exact same thing for about 5 more minutes. I'm sorry I didn't get all of it, but I wanted to play it because it's silly. And like I said, it doesn't end. It just goes back and forth. And then Regier at the end of it, the judge says, Regier, do you have anything to say? And he's just like, no, nothing from the state, Your Honor. Oh, Debbie, you saw it all. If somebody has that whole clip on some, like if I don't know if OSG has it or someone else has the whole clip, someone please drop the link because people need to see that entire clip. But that's all of it that I got before they took it down. All right, next clip. Here we go. All right, now we're going into a lot of Simpson. I think think the rest of this video is Simpson.
Does call the case of Group 5 Management versus Roderick Smith.
Good morning, Your Honor. Carrie Zanin, P7, on behalf of plaintiff, standing in for Mr. Weiss.
All right,
Good
this one
afternoon.
is
How
from
you
a
doing,
few
John?
weeks.
What's your name, sir?
Instead of talking over the video. This one's from a few weeks ago. Then I think the last two are from today. And I think that's going to end the video. I'm guessing.
What is the claim in this case?
Judge, this is a non-payment of rent action with a money judgment being requested as well. I'm showing that rent is due in the amount of $1,588, court costs of $217 for a total rent retained of $1,805.
Sir?
Yes.
How do you intend upon paying this?
So, Your Honor, I actually tendered payment to Group 5 Management on November 3rd. And my form of payment was refused.
Was what?
Form of payment, she refused payment.
What was your form of payment?
A cashier's check. I actually have the voided check here. And I'm asking for
You had a
yes.
cashier's check? Let me see.
If this is also the refusal in the email from the landlord. All right.
Danny, do you know anything about the refusal of payment?
I do not, Judge. Obviously, I'm standing in for Mr. Weiss. I believe my client or the client was supposed to be on. My understanding was that it wasn't a cashier's check. It was a counter or a check. And the reason it would have been refused was because he's had more than 3 checks come back as insufficient funds. But I would ask if I don't see if he's on here, Judge.
From Randolph Court or Group 5 on the Zoom? We don't have anybody checked in.
We don't.
Email.
Judge.
Hang on, Ms. Zane. He has an email saying about the refusal. Well, it's a text message screenshot.
Yes, it's a email. I actually screenshotted it.
And it says from somebody with the last name of Aslam, ASLAM, indicating that they received the rent check in the sum of $1,238, which the check that he showed me was in the form of an over-the-counter check. However, must be certified funds. And then, second page, as the system will not accept this, maybe. But
Yeah, Judge, my notes on the ledger show counter check, which is a check that's not, it's one of the ones they give you from the bank. And so again, that's the position I was taking anyways, it was refused.
So,
because
sir, yes. Is there a reason why you can't get certified funds to the landlord?
Well, they actually accepted December's rent from the same check, Your Honor, from my bank.
Okay, but if?
Well, because it costs. And my defense is that under Uniform Commercial Code 440.2511, by tender of payment, 2 and 3.
It's not applicable to this case.
And could you tell me why, Your Honor?
Because the UCC doesn't apply to this circumstance.
I'm sorry?
The UCC doesn't apply to this circumstance.
It's a commercial transaction, Your Honor.
The UCC does not apply.
Okay. So where could I find this at that says that this isn't a commercial transaction?
That would be your assertion. I'm telling you it doesn't apply to this.
Just for my understanding that the Uniform Commercial Code governs all commercial transactions in commerce. And so based off of this law, tender of payment is why my defense is that once the tender of payment was refused, at that time, the charge or the total amount
And
was
you can't,
discharged.
even if you were to do that analysis, you can't then have unjust enrichment, which means that you want to move.
I'm sorry.
You can't have unjust enrichment, so you'd have to move because you can't have the apartment and not pay.
No, I mean, I paid the rent. They took the exact form of payment in December.
Sir, are you going to tender a check or no? Or certified funds to them?
I'll tender payment.
Are you going to tender certified funds for the 1805?
So, Your Honor, my rent is $1,238. And just the extra $700, $600, I'm not sure where it's coming from. But if they accepted the rent payment and from my bank in December, I'm sure, I don't know why they wouldn't accept it now. They refused November and then
Okay.
they accepted December.
Sir,
Yes.
I'm asking a very simple question.
Yeah.
Are you going to tender certified funds to them in the amount of 1805?
I will surrender. I will submit funds.
Certified funds?
Is this guy SovCits? I feel like he's teetering. He folds too easily, in my opinion. I don't think he is. I think he read some things online and thought these arguments would work. I don't really know if he's a SovCits or not. I did put this clip in here because he may be, and he fits perfectly with SovCits and Idiots. But what do you think? Do you think he's a SovCits or not?
Funds to them.
I plan to. It costs me to do certified, so I would.
As does
I would
the
like
NSF transactions that they've had in the past. So that is my question to you. Are you going to submit certified funds
I'll submit certified funds.
in the amount of 1805?
I like to debate that amount because I'm not sure where that amount's coming from. My rent is $1,238. In court costs, I'm not sure what the other $600.
All right, here's what I'm going to do.
Yeah.
Defendant to submit 1,238, which at this point is the undisputed amount in certified funds to the landlord no later than December 29, 2023. And then we will look at the disputed amounts. I will adjourn this matter to January 5th, 2024 at 2 p.m. And I would just note to you, Mr. Smith, that if those funds aren't in, I'm not hearing any additional argument. I will be granting a judgment, which will be for the full amount, plus what will at that point be January's rent.
Your Honor, also, the 4th I have to work, so every time that I'm coming here, I'm having to take off of work. And
Sir, I cannot help that.
I mean, is there a way that we can set a different date?
That is my next day.
Okay.
Thank you.
Thank you, Your Honor.
Court calls case of Hampton.
All right. The last two cases, I believe, are just Simpson. Again, I put a lot of clips in this video. The last two are Simpson from today, I believe, unless I snuck in the third one. But I have two back-to-back well, I guess technically three back-to-back Simpson. But if you haven't done it already, please hit that like and subscribe button. It does really help the channel. Thank you all for being here, and thank you all for your support. Let's go watch some more of Jeff Buffliff. Judge Simpson with the Buffliff. Now I can't even talk.
And sometimes that may amount to nothing, which would also then flow into the parish. You were going to say something, sir?
Yes, actually, I just left the meeting from the city township hall this morning. They actually need me to address to you that actually under city ordinance, it doesn't fall under the, there's an act called the Mobile Home Park Act of 1987.
I'm familiar.
You guys want to know who the interview's with? a lot of you already know. Not a lot of you, a few of you already know. It's, I might tell you at the end of this. If I get, I don't know, I can't see how many likes are on this video. There's 191 watching. If I get to, let's say 150 likes on this video by the end, I will tell you who it is. I don't even know how many likes there are. There might already be 150. I don't know. So I probably should look to see how many there are before I say that. But yeah, so we'll make that a deal. If I get up to 150, I'll tell you who I'm interviewing on Monday.
What they've been doing this a minute. Go ahead.
In order for
On the premises,
Requests for repairs. There's been
I mean, now that I
I
can't
don't-
edit videos, maybe I should just tell you anyways.
yeah, you do something on this. Oh, no, that's the other one.
All right, now we're going to where I wanted to go.
Pleasant Lake Park versus Ryan Holicki.
I don't remember. I really don't remember why I put this guy in here. He wasn't too
All
special.
right, your name?
The case after
Ryan
this again.
Holicki.
All right, where are we on this case?
Judge, this is our second hearing on a complaint for non-payment of rent. We've got rent to retain of $3,776 plus late fees of $170.55 for a total of $3946.55. We're asking for
Give me that total amount.
$3946.55. We're asking for the judgment, money judgment and possession.
Sir, what's your position on this?
Well, actually, that would be left up to you because unfortunately, this property has no C of O on it. And also the mobile home is also being owned and operated without a license either. And the trailer that I'm specifically in is 100% uninhabitable, as I have pictures of my trailer just continue to mold spread.
So,
I think I think you might be confused. I had a job interview yesterday. I'm a programmer. Interviewing a judge on Monday. So that's what everyone's asking me about. Is they're asking me what judge I'm interviewing, because I haven't said who I'm interviewing. And I think there's only about 6 or 7 people in the chat that know who I'm interviewing. But yeah, just to catch you up to what's going on.
this is a trailer that's in a park.
Correct. 18 trailers reside here, as I think there may be even more than 18.
And what township is this in?
Manchester Township, Your Honor.
Do you know anything about a CO?
I do not, Your Honor. This is the first I'm hearing about this. I assume that this is, was not raised at our first hearing. He did not dispute the amount owed, made no answer, has made no written answer. I don't know if this is the case. I don't believe it to be the case.
Actually, I have photo proof of emails from Freedom Township Hall officials, and I have a screenshot of that email. They confirm there's been no C of O on this property any time prior of 2000. Their database only goes back from 2000. So that would also mean this property has gone almost 24 years of not ever being certified, inspected, or of C of O.
I am interviewing a really fun and interesting judge, someone that I've covered multiple times on my channel. Interviews at 10:30 Monday morning. It's not going to be live on YouTube. At least I don't think. If it is live on YouTube, it'll be live on their side, not mine. They have a YouTube channel. They're going to be on the bench when I interview them. I will be on their Zoom. So if they choose to make it live, it'll be live, but it's not going to be live. I will play it afterwards. I don't know how soon, but it's hopefully by Monday night I'll have it up. But I'm going to send them the video and let them look at it before I play just so if they want me to edit anything out, I'll edit it out. So hopefully I'll have it up by Monday night, but it might be Tuesday when I actually have the video out.
Is it licensed as a park?
Yes, it goes under Pleasant Lake Valley Park LLC.
Well, okay, but does the city, I think they're now the city of Manchester will be, do they require a license for the trailer?
Correct.
Okay, and do you know whether or not there is a license for the trailer park itself?
There is not, according to.
All right, and then separate and apart from that, there is then the COs.
Correct.
And you're telling me that they don't have COs either?
Correct. On any of the trailers on their property, which would be, that's a separate charge per trailer violation.
Yeah, okay, I know, but, all right. And Counselor, you know nothing about this?
That's correct, Your Honor. I would note, Your Honor, that there has been no complaint from the tenant prior to today of any condition, of any repair, any escrow that's been made. There's been no escrow, Brent. There's been no repairs made and funds escrowed for that. And there's a portal open wherein which the tenant can make requests for repairs. There's been no requests. So
this is true. However, the landlord has been notified 3 times. However, it's been verbal conversations over the phone between my wife and him.
Okay, so first thing I'm going to need from the defendant is a written answer. And I would indicate to both of you that I understand what the repair issue, that is certainly would be part of it. But then the question is going to become under the ordinances of the city, the village, now city of Manchester, whether or not the park can properly operate as an entity renting units or lot space. And then the question also becomes, if there is no, and if they can, if there's no CO on the premises, what is the remedy for that? And that I don't know without looking at the ordinance. The ordinance may specify one, it may not specify one. If it doesn't specify one, then it's up to the court. I will give you both some guidance as to how this court has ruled in the past. And that is that absent authority to do so, the question becomes what rent would be due and owing, and sometimes that may amount to nothing, which would also then flow into the repair issue. You were going to say something, sir?
Yes, actually, I just left the meeting from the city township hall this morning. They actually need me to address to you that actually under city ordinance, it doesn't fall under the, there's an act called the Mobile Home Park Act of 1987.
I'm familiar with, they've been doing this a minute. Go ahead.
In order for inspectors to come in, it would actually have to be state. That they said, according to the city ordinance, they can't do anything about it, that state inspector officials must come.
For the park?
Correct, in order to get the C of O.
No,
I will tell you guys, because it's the most often guessed, it is not Judge Simpson and it's not Judge Middleton. I will take those two out right away. Neither one of them. And because a lot of people have said Judge DeSanto, it's not Judge DeSanto either. Take those 3 out. There's only about 5 judges left that I really cover a lot on my channel. So there's your hint. Unless we get to 150, I see 139 right now. So if we get 11 more likes in the next 15 minutes, I'll tell you who it is. Otherwise, you have to wait till Monday.
yeah, I mean, I get what they're saying. That doesn't really relate necessarily to what I'm saying, because even if that beginning portion hasn't been done, the question then becomes, what is the remedy? So, sir, with regard to all of those claims, how long will it take you to file a written answer? I need it in writing to the court as to what your claims are. I've heard you that there are really three claims. There are repair issues, there's the C of O issue, and then there is the license to operate the park. How long will it take you to put that in writing? You have to put it in writing to the court and then serve counsel with it. How long will it take you to do that?
Me, myself? I could probably.
Well, I don't care who does it for you, but you're gonna have to sign it. How long is it gonna take you to do that?
A day.
Okay, well, I'll give you 7 of them. So I'm gonna say answer and counterclaim by the 12th. And you heard me that you have to give a copy to the court and you have to serve it on counsel.
Okay.
I will then adjourn this matter out to January 19th, 2024, 10 a.m.
Thank you.
Thank you. Court does call the case.
All right, we're moving on to the last clip. A lot of you guys were mentioning this clip when I first started the video. Saw a lot of people talking about the what were they doing? The garnishment case in Simpson. This is the garnishment case in Simpson. So if you guys haven't seen this, this is good. Judge Simpson gets angry, and I don't doubt him. It's one of the rare times the judge gets angry at an attorney. He actually defends the defendants. No, excuse me. It's good. All right, what do we got? I see 6 likes away. I'm going to let this play, and I'm going to pause it. I'm going to just let this clip play through. I'm going to pause it at the very end. So if I hit 150, and I think this clip is like 8 or 9 minutes long. So I'm going to let this play. I'll pause it at the end, say my goodbyes. If I hit 150, I'll tell you guys who the mysterious judge is. If not, again, you're just going to have to wait till Monday. Let's go.
Ping Shen versus Croy Akafong. Steady Croy Akafong and FC. Right. State your names for the record.
Sade Caillou Ashampong.
Osei Ashampong.
Chris, I'm going to do it tomorrow night. It's a very important message, and I need to be able to say it with a clear head. So I'm going to do it tomorrow night instead of tonight. Because I'm asking for help, and it's hard for me to ask for help. So I'm going to do it tomorrow night when I'm not overthinking everything. So I'll do it tomorrow night instead. But thank you for bringing that back up, because I did tell you guys I was going to say it, and I didn't. So it's going to be tomorrow night instead. But thank you.
Judge,
All right. And what are we doing on this case today?
Your Honor, you had scheduled this for just a review to be brought up to date, I imagine, on what
the payment plans. Yes. So how is it going?
To date, they've paid.
All right. And so how much is left owing on this?
$2,660.12.
So at $500 a month, it's going to be, oh, go ahead.
And I also have like an additional 500 monthly. When we had our case in our final judgment, I believe that was.
What she's saying is we were on the case together. So when we came to court the last time, you had dismissed my garnishment. My wife's garnishment didn't go through, so hers continued. When we put the paperwork in, he made it as another case, so she's still being garnished.
Well, it's $150, so I get paid.
It's additional to the 500 that we had already agreed to. So we're trying to figure out why and if we can stop that garnishment, because we're already splitting a payment of $250 Because we're on the same case for $500.
So right now, he gets 500, which was the case that was judgment, and then I pay an additional 150, so a total of
Okay,
650.
so hold on a second, ma'am. You pay that additional 150.
Yep.
How?
$75 is taken out of my check every 2 weeks.
Got it. Mr. Mack, you know anything about that?
Yes, Your Honor, the defendants have actually misstated the facts. There are two judges in that case, two judges. So they are equally liable. So Mr. Ecumengapong.
Hold on, no. So how?
Because we're on the same case, sir.
Sir, I didn't ask you to state anything to me. So, Mr. Mack, these parties agreed they were going to pay $500 a month.
No, they did not.
Oh, I'm looking at it right now. I'm looking at it on September 1st of 2023. You were present in my court.
Yes.
Defendants to pay $500 per month. Defendants.
Okay, and so what I'm saying is the judgment against Mr. Ecumengapong was ordered by you at $500 a month. At the time, there was no garnishment against Mrs. Ecumengapong. That's why we sued them both individually and severally.
So hold it, when did the garnishment happen?
The garnishment happened through the Ypsilanti schools. The garnishment was.
No, when was that ordered? When did you request a garnishment?
That was ordered by this court.
Where's Ann?
I can say this for real right now. It's about to go down.
Okay, first of all, Your Honor, with all due respect to the court ordered me to prepare an order of garnishment concerning this here argument. And the order clearly states, as of September 15, 2023, and no later than the 15th of the succeeding months, the defendant also Ecumengapong is to tender $500 per month of plaintiff. And then, so,
all right. No. Man, no. You can play those technicalities all you want with me, but here's the reality of it. The motion and affidavit for installment payment plans was filed in both of these defendants' names. Out of that motion for payment plan, I suspended garnishments because I would have to do that when I order the payment plan. If the order is incorrect, then I'm vacating that order.
I've got both right here.
Both what?
Separate names, separate garnishments. Right here. Right here.
Show them this. Their motion and affidavit for payment plans.
Sorry to keep pausing it, but I noticed that too. The little thumbs up that came up and then the balloons. This was on his live. I got this from his channel. So I have no idea where those balloons came from. So someone on his side was doing that. I don't know. I don't know, but I didn't get this from anywhere else except for his court channel. So no idea where those balloons came from.
At the top, both names. It is, in fact, once I ordered it, illegal for you to garnish either one of their checks when I've suspended it.
I'm going by what the court has ordered for garnishment. You asked me a question.
Okay. If you're saying, give me that file back. And Mr. Mack, we're going to make it right. Today. All garnishments are hereby ordered suspended. as to both defendants. Defendants, plural, shall pay $500 per month as previously ordered.
Your Honor, there's something else I'd like to bring to the court's attention. Your colleague, Judge Barr, issued an order stating that Mrs. Angamendapong would pay $150 a month. I don't know if that's
Vacated. That's not what was ordered on this case. If you want to bring that up before Judge Barr and he wants to discuss it with me as to which order will hold, you can. But I will tell you in this case that these funds are coming from, it is $500 per month. As I've indicated, any garnishment that has been issued is hereby ordered by this court suspended. Counsel for the plaintiff will prepare that order and have it on my desk by Monday morning. Thank you.
Thank you.
Will the date of the 15th,
Are we finished?
will the date of the 15th that you had ordered and the
Date of the 15th of what? The payments? There'd be a payment 15th of each month, as it's previously ordered, but only $500.
as to both of them combined. So, and I want to get this clear, and there's nothing.
I think I'm very. These two will pay $500 per month, Mr. Mack. That's it. There'll be no other garnishments of any personal wages or anything along those lines. Those are all suspended. You will prepare an order to that effect, my desk, Monday morning.
All I'm talking about is the mailing of it because of the issue, okay? So, these folks, they pay $14 to have some kind of expedited mailing, and they keep doing that. But I'm saying as an officer of the court, and in fairness to them.
Well, what? You now want to be fair to them?
Well,
seriously?
Well, Judge,
He set up an agreement where we could drop something off.
Well-
He told us that we could not drop it off at his office and that he designated a specific place
yes.
and someone else to give it to. So therefore and it was only once where I did certified mail for it on the 15th to be sent to him.
Yes, and they can keep doing that. They can well keep doing that.
It costs more money to do that. The reason that we said we could drop it off on the 15th
Oh.
because we don't get it until the 15th. So we wanted to drop the money orders off as soon as we get them. But he's not allowing us to do that.
Well, it isn't that, it's about dropping it off. But.
Well, he instructed us.
No, here's what we're gonna do. Your $500 per month, you need to have it in cash. Defendants to pay monthly payments on the 15th of each month into court escrow.
Okay.
So you just bring it here, the $500. I don't know what their problem with taking your money. We'll be more than happy to take your money.
Thank you.
That's fine. All this is done for their convenience, that's fine.
I'm done, Mr. Mack. Have a good weekend.
Thank you, sir.
Court calls.
Yeah, wrong button. That was fun. My favorite part was when Judge Simpson went, ah! It was good. It was good. All right. I promise you guys, 150 likes, I'll tell you who I am interviewing on Monday. It's not going to be a surprise anymore, but a deal's a deal. It's a judge. It's a judge. I'm interviewing him in his courtroom on his Zoom channel. I said that already. Don't know if he's going to have it live or not. Probably not. It's at 10:30 a.m. on Monday morning. And it is Judge Slavin. Judge Slavin. Not Simpson, not Middleton, not DeSanto. Those were the biggest guesses. Judge Slavin. And yeah, I'm really excited about it. He's one of my favorite judges. I reached out to him after one of his epic speeches on was it a SovCit video? I think it was a SovCit. He had an epic speech, and what happened is I heard it, and I instantly just got the urge. I'm calling his office. I want to talk to this guy, and I called him, and I got his clerk, and I just said, "Hey, I want to interview him." And she's like, "Who are you? What do you do? Whatever." Took down my information, and then we started emailing back and forth, and we are, scheduled to interview 10:30 a.m. on Monday morning. So there we go. With that being said, if you guys have any questions you want to ask, since I'm not going to have it live on my channel, so you know what? Yeah, I'm not going to, I don't think I can do it. I don't think I can do it. I don't want to do it to him to have it live on my channel. But if you guys have any questions you want to ask, email me, super chat me with the questions, and I'll put them into the interview. But yeah, that's what's going on Monday morning. That's all I got. Video's over. Just wanted to let you know. I'm going to go live tomorrow night. I've got. Do you guys? The video I had, I think it was 2 days ago, about half the police department resigning. I've got the follow-up video from that, the next town hall meeting after that, where all the citizens are yelling at the board. I've got that yesterday. I'm going to make that a premiere tomorrow morning, and then I'll go live tomorrow night. So that's what you guys have to look forward to tomorrow. All right. That's all I got. Thank you, everyone, for being here. I appreciate each and every one of you. If you haven't liked and subscribed already, please do so. That's all I got. So we're going to jump in Discord after this. We'll hang out in Discord for a little bit. But if I don't see you guys till tomorrow, until next time, bye.
Hey,